for February 17th, 2011. We have one initial order of business that we'd like to do from the board. This year we started without one member on our board that has been on our board for many, many years. Kathy, could you come up here, please? That's right. We got you a gold-bound copy of the zoning code. Yeah, thank you for all your service to the township. And speaking for myself as well as for the board, I will personally miss you. Everything I know, I have to contribute to this woman right here because she kind of kept me for all the years I've been on the board, and she is truly an expert and a person who really, truly has Radnor Township at heart, and you will be sorely missed. And you need to come back on as soon as you can, because we need you. We not only, we need your understanding and your keeping us cool and calm in the face of many adversities that we have. And I personally thank you as well as everyone. Thank you. Yeah. See if it's working. Why don't you open it also? See what is that working? I don't know how they work. I never used them, Mike. They give me one here.
Use the on switch.
There you go.
Works. Yeah. I just want to say thank you very much. I've really enjoyed my time on zoning, and I've learned a lot for somebody who's not an attorney, but I did serve 16 years on planning, so that gave me a lot of great background for zoning on here. But I really enjoyed my time. I learned a lot, and I doubt that I was the one that kept it calm, Charlie.
Oh, absolutely. Absolutely. Okay. I can tell. You and Cora are kicking me under the table.
Well, just a little. Just a little. Okay. Thank you very much.
No, thank you. Would you like to open it and see what it is, please? Oh, I don't know. Well, we had John do that because we were afraid if any one of us did it, we'd probably do something wrong.
Well, thank you very much. I really appreciate it.
Thank you. Why don't you put that down there for me, will you? Thanks. Thank you. You want this box, Kat? Do we have anything else, Matt?
I'm going to take the box.
You want?
Oh.
I don't know his name.
Thank you.
Sorry about that.
Also, we have a new member as an alternate, Matt, Brad DeLizia. Did I say that right, Brad? DeLizia. And we also have a new permanent member, and that's Noah. So he's been around a while. So we now have a full complement of members on the zoning board at this time. Welcome. All right, the continuation from the last meeting, Appeal 2844.
As the board may be aware, we've had a stipulation that's been circulated, and I know Ms. Price and her counsel just saw it probably a couple hours ago, and Mr. Rice and Valley Forge and Eastern are still trying to work through it. My suggestion, if everyone's in agreement, is perhaps that we continue to next month, see if we can agree to somewhat of a stipulation of facts. Some facts are not going to be stipulated to, obviously, but at least regarding maybe the ordinances and when they came into effect and things of that nature, perhaps that could be stipulated to. And my suggestion, if everyone's in agreement, is to continue it until next month. And at that point, hopefully we'll have a stipulation. If we don't have a stipulation, we would present more evidence, and we may even present more evidence at that time, too. I know that Ms. Price and her counsel may want to present more evidence, and we may also. But instead of just doing it piecemeal, my suggestion is maybe that we continue it to next month.
Mr. Rice, are you in agreement with this?
Yeah, I know the two resident parties are just looking at this stipulation, and I made some comments on it in the last day. I think that most of the facts aren't in dispute in this case. It's just going to be a question of how's the zoning ordinance going to be interpreted and what zoning ordinance was in effect, and, you know, they're the issues. What I would like to do, though, is have the stipulation submitted to the board prior to the next hearing, if we can do that. Sure. I mean, not at the hearing, but prior.
Yeah, I was going to suggest that, you know, we should get to see the stipulation.
And the other parties, Colleen Price, Christina Peroni, you know, need to sign off on it too, or it's not going to be a stipulation. And if anybody has other testimony beyond that, actually, if they have other testimony, they ought to try to put it into the stipulation that gets submitted. So that, I think, would cut down on several hours of time. And if there's still things that folks want to put on in terms of testimony,
That
if
works.
it's relevant and you let it proceed, then we'll do
Okay.
that next time.
Okay, Ms. Price, are you Ms. Price's attorney?
Yes, I'm sorry. Bernadette Kearney from Hanberg Rubin, here on behalf of, I should say, Ms. Price is also an attorney, so she was representing herself last month. I called myself co-counsel. I just spoke to Ms. Price, and I do think that her husband, Brian Price, wants to go on and put testimony on tonight. And we were talking, the other witness that we wanted to ask questions of was Matt Bauman. And I'm discussing that with her. Just want to confirm that Matt would be available next month for questions?
Yes.
Yes. Okay.
And if we do this continuous, I would do everything. I would not have someone do some things tonight and go back again. I would like to do everything.
At one time?
Yes. That way at least we have some continuity. I think that doing it piecemeal is not really the best way of going about it.
And so you would want Mr. Price to
Yes,
be here next month?
yes.
Mr. Price, are you available next month? I just have to confirm that. Okay.
Great, thank
The
you.
other thing that I had spoke to Mr. Rice about was, and I think Mr. Schubert had alluded to, was the party status of Colleen Price apparently had not been determined at the last hearing, and some of that was why we didn't get the stipulation, and the exhibits that Ms. Price had put in weren't part of the stipulation. And I wanted to confirm that that decision is going to be made, if,
Yes.
hopefully tonight.
I thought you didn't.
No, there was an objection to standing. You know, we can decide that, or just permit the person to formally make a ruling. The fact that the objection to standing has been made preserves the rights of Eastern. My advice to you is that Ms. Price clearly has standing.
I agree.
Okay.
And Ms. Peroni.
Yeah.
Yes.
We have to.
John, do you have a schedule? You want them to get this information to you?
If it's a stipulation, I would be happy to have it, if we could get it 7 days in advance. Would that cut the mustard for the board?
Is that enough?
7 days, yeah, I just want to receive the facts. We've gotten briefs. I don't think we're getting
Is that
any
enough?
more.
7 days for everyone? Okay. Is that okay?
That's fine, but I would, you know, we're going to have probably a much larger document than we can circulate it around this week. So 7 days is fine, but I'm going to reserve the right to also submit some additional memorandum of law. It'll be short.
Do you want to come up here, Mr.? I'm not sure they're catching you on the camera. Thank you, Mr. Rice.
I mean, 7 days is fine. The stipulation, if we're going to have all the parties now involved in this, this is going to be probably a lot larger. There'll be documents that might be attached to it. But I also want to reserve the right to submit any additional legal memorandum. There's a couple issues that have come up. They've asked for all types of relief, not just that you overturn the notice of violation, but they're looking for non-conforming use status, they're looking for special exception. So I want to reserve the right to suggest some conditions if you grant any relief, because I think conditions would be appropriate if you grant any relief, which I don't believe they're entitled to it, but I'm still going to cover that base.
Just let me ask you this. if we've had this brief, we've had a lot of stuff, we've done a lot of work, we've had an executive session to discuss where we seem to be. I personally, if I could get this by the close of business the Monday before the hearing, that's enough time for me to review it. I don't know if that's too, if people think that's too much, but I know they have a lot to do.
Yeah,
It gives them
I
another
wish,
week.
I would rather have it get it before, so if we could possibly get it, we have it by Monday, because if you get it on Monday, we're not going to get it, get any input from you until maybe Tuesday or Wednesday, and our meeting's on Thursday.
Your meeting next month is,
It's always the third Thursday.
that wouldn't happen to be the 17th of March, would it?
And by the way, the basketball's going on, too.
Oh, okay.
I mean, do we want to continue this to April?
Do you want it to go
doesn't.
to,
It doesn't.
17, the only thing about the 17th is the day for my wife's birthday, that's all.
So the date you want these submissions would be the Monday or the Friday? Because
I mean, does anyone have a problem with the 17th of March?
The only question I have is, I think the board can always meet on the 24th of March if you wanted to. I mean, I
We'd
don't
have to
know.
go get
It's
into
up to
getting
you.
the room.
Yeah, but we don't know if we'll get the room.
Yeah.
And it might be a lot of people.
I mean, one of the things, if there's work toward a stipulation, I don't know if there's some hope to settle this. Do you want, I mean, it's up to the board, but would you want to hear this in April to give yourself some time? Do you need the time? Is the time useful? Is the time useful? I don't know if it is or not.
24th is open, though. March 24th, the room's open.
No,
I'll be here on the 24th.
no, well, we'll either hear this on the 17th or in April.
Just so the board knows, I have two other hearings that night on the 17th that I'm going to have to find coverage for.
Yeah.
So this would be the third.
I understand, and I appreciate the conflict, but the board meets for the township purposes on the 17th. If you want to move this to April, we'd be more than happy to do that as well. Is there a time constraint on this to be done?
Well, I think we can work right now.
Plus, it gives you more time to get more input from people in the neighborhood as well.
Right. I think right now we can keep it at the 17th of March, and if the parties all decide to move it another month, we'll be back to you, but...
Okay, and you can, Mr. Brown will take that, and he'll get that to us, and it'll go on the sheet that'll be moved back. So you can kind of go through, and if it looks like the 17th is going to be a problem, then move it in, just, it'll
Right.
come to us, and it'll be announced from the board that it's been continued to the 24th, as we have done in the past, so it's not a big...
To the April meeting.
To the April meeting,
April
I'm sorry. It will not be on the 20th, it will be the 17th.
So assuming it's March 17th, you want the submissions from all the parties, a stipulation on the Monday or the Friday before the 17th?
I would like the Friday. Is that okay?
It's up to you. I mean,
I just think that it gives John more time and us more time, because
Yeah,
by the time it filters through John to us, it just gives us a little bit more time and be a little bit more well-versed before we get here.
Okay.
Okay?
And just be aware, I'm sure the stipulation's not going to cover everything.
We understand, but it'll maybe keep it a little bit minimal to what we have to do that night. Ms. Price?
No, my name is Christina Peroni.
Peroni, I'm sorry.
That's okay, that's okay.
You dropped your...
Sorry, I dropped your microphone. Couple things procedurally. I am not an attorney, but I am party to this case. So procedurally, I did not receive any of the exhibits. I didn't receive this memorandum that was circulated. So can someone procedurally explain to me how, and my understanding of this, again, I'm not a lawyer, is that everyone's going to write down the facts that they believe are true and all parties agree? So what is it, just emails go back and forth where we all say what we think is true? And like, how does that work? Just
no,
so
we
I
need
understand.
something signed. We need something signed. We don't take
Well, I
unsigned
understand, but
emails
how do we
for a stip.
agree, how do all the parties agree on how,
This is, you can have this. It'll be a document like that. It is numbered.
okay?
There'll be 30 or 40 paragraphs, and you add your additional paragraphs to it,
Okay, and so.
and then circulate it
And
among
remember, it's going to be
Yeah,
facts
okay.
that we all can agree to.
Right.
Sure, I
mean, if there's gonna be
understand that.
stuff,
Yeah, I understand that.
Put your email.
Oh, yeah, okay. So we all get to add to this and
Yes,
go back and forth?
that's the reason why we're going to do this, is to try and make sure
That everybody-
that everybody's in accordance, or the best that they can be in agreement as to what the real facts are.
Got it.
So that we're not arguing about facts.
Things that everybody agrees on.
everybody- right.
Makes sense.
That's
Saves
exactly-
time. That
Yep.
makes a lot of sense.
It's like when I say, don't, bring new information and not rehash the old information, because it
Got it.
only makes things more difficult.
Okay, fair enough. Okay, perfect.
Okay.
That's fine and agreeable to
Great,
me.
thank you.
Bernadette Kearney again. My client just want to confirm, a little nervous, that she can have any witnesses she wants at the next hearing, and that Mr. Baumann will be present for questions.
Mr. Baumann will be present, and she can have whatever witnesses, as long as they're relevant to the appeal.
Relevant to the appeal. And also that the memorandum of law, again, all attorneys like to write them. We probably also will, again, provide
Okay.
another memorandum
Yes.
of law. We'll
I
try and
think
keep it
Make sure
everything
short.
is
Mr. Ryan has it
Due
in
by
a timely fashion.
everything is due,
Due by the
memos of
Friday.
law.
By
due
that Friday before the
Yes.
hearing.
Friday.
Okay,
Okay,
thank
and the
you.
hearing will be the 17th. If
I-
you all get together and decide that the 17th is not going to work and you want to meet in April, you need to let Mr. Baumann know that so that we can proceed accordingly.
There's a couple of things that we need to do. First of all, we need Easterns, and I think VFMA's as an intervenor consent to these extensions.
course.
Whether it's March or April, you consent to whatever extension we get to, and the time period.
Consent for the hearing as well as
and
for the written
45 days
decision.
run
45
after
days
the
after
conclusion.
the final hearing,
of the
conclusion of the
final
hearing.
Secondly, we did receive a request for subpoenaing witnesses. The board does, that is up to the discretion under the statute to the chair. My recommendation is, if they're working on a stipulation of facts, that we hold off addressing the subpoenas until such time as, we see what, if anything, comes out of the stipulation of fact, because that may obviate. I mean, from my viewpoint, I don't see a huge amount of dispute as to, on the facts, and to the extent that the facts, we can do that without having to have subpoenas. I think we ought to hold off on deciding the subpoena at this point, Mr. Chairman. That'd be my
Okay,
recommendation.
I agree.
Last, I did receive an email today requesting that Mr. Falcone recuse himself. Does anybody wish to pursue that at this time? We have to address this, I think.
Good evening,
You-
everybody.
You need to be sworn in?
If you raise your right hand, you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes, I do.
And state your full name, please.
Diane Edbril, Edbril, 205 Spruce Tree Road in Radnor. Good evening, everybody. I'm not a party to this action. I don't live adjacent to the property in question, but I do live very close by in the vicinity and drive by there regularly. That's sort of more of a factual thing that I think is better saved for another day. But regarding the conflict of interest, that is something that over the years in Radnor Township I've been involved with. I've helped bring light when
Just a second. How far away from the property do you live? How far away from this property do you live? Because I got an email request, and that's not enough to be a request for
Well-
recusal. If somebody with, if
No, I'm here as a.
But the email didn't come purportedly from you. It came from somebody else.
No, but I'm familiar with the situation, and as a resident of Radnor
But
Township.
you haven't answered the question. How far do you live from the property?
I live on the other side of King of Prussia Road from the property.
So she abstained?
So what is
How
that?
far- how many-
3/4 of a mile?
I think at 3/4 of a mile, I don't think you have I don't think you have
I think that the conflict of interest, conflict of interest matters affects everyone in this township, whether they are adjacent to the property that is
that's
before
not
the zoning hearing board or
We're not
not.
hearing other properties, we're hearing this property.
Yeah.
But you, sir, are hearing about this property, and there has been a request made that you recuse yourself because you are a student housing owner in Radnor Township. And how the outcome of this hearing goes
We're not talking about student housing,
will
we're
affect
talking
the
about
student housing market. Well, with all
I'm
due
not going to recuse
respect,
myself. I'm denying that.
Well, then I would just like to state for the record that I think there's a clear connection
But you have no standing in this case.
between, so, well,
Thank you.
No, you know,
John, who is it who sent the email requesting
That's
recusal?
what I
I
wanna
sent
know.
the email.
Okay, now
I
you
sent
can
the
speak.
email. I sent the email. I just, for the record, Christina Peroni, if I need, do I need to? No? Okay. According to the zoning hearing, the zoning book, it's 280-151, it says, just for the record, residents' right, at any public hearing, there's the opportunity for any resident of the township to be heard, in addition to parties of interest. So if I would ask Mr. Ryan to re-review that, that would be helpful. Secondly, quite honestly, and I'm a big fan of being honest, I thought, Mr. Falcone, you were pretty tough on us, and I didn't understand it, because we're residents, we care about our community, and I didn't understand why you were so tough on us. So I did some Google searches, and your name came up as owning student housing. I then put through a right-to-know request for information and saw in your statement of financial interest, as you know, that it says that you own these student housings. Of course, I am a business owner, I am a landowner, I am a commercial, I am involved with commercial business. I am an entrepreneur. I love all those things. But when you are directly hearing information where you can benefit by being, there's only 4 or 5 main institutions. There are 2 or 3 that are affected by this decision as to whether Cabrini, Eastern, or Valley Forge students could possibly be one of your tenants. So it's, again, I'm not an attorney, but it is just the appearance of conflict. I pulled out the PA State Ethics Conflict of Interest, and it says clearly you are considered a public employee because you are appointed by a government agency, so that applies. Then it says under conflict of interest that any conflict of interest, broadly defined, basically it goes through if you can vote and that outcome could in some way benefit you, then that is something that could be considered. And I'm not saying you're immoral. I'm not saying any of that. I'm just saying let's be really clean and open. And I think at the beginning you should have presented yourself as having this.
Okay, if I rented to Eastern students, if I rented to Cabrini students, all right, my houses are so far away from the other end of the township that I have no interest. Plus, we're not even talking about housing, we're talking about parking. It has no relevancy to it.
I completely disagree. The reason parking is relevant is if you grant these people the right to use 350 parking spaces that are not connected to their university, that means, therefore, they can have that many more students, and that many more students will eventually need housing. If what you're saying, maybe you've never rented to these 3 institutions, Cabrini, Valley Forge, or Eastern, would you then be willing to say, I never will? Of course not. You shouldn't. That's a silly thing to commit to.
Ms. Perone, I reviewed the email and have given my advice to the board, right or wrong. I do not think the case law is very clear that where a board member feels that he or she may hear a case fairly, in the absence of violating something like the Code of Professional Ethics for the law profession, which is not in play here, a reviewing court will respect that board member's decision. Personally, I've worked with Mr. Falcone for many years. He is a meticulously honest man, and my advice to Mr. Falcone is that he should not feel under any compulsion to recuse himself in this situation. I do not agree with the request, and I have advised Mr. Falcone, who makes the decision on his own, of my thoughts on that matter.
Okay, I appreciate that. Mr. Ryan, you are paid by the township to represent the interests of the zoning board? Is that what your relationship is?
I only represent the interests of the board and its
and
members.
The zoning board. And the zoning board's interest is to represent the will of the public at large?
No, it is not. The zoning board's job is to enforce zoning law under our ordinance and under Pennsylvania state decisional law and constitutional law.
Right.
We have had to grant approvals, I know in the past, that the board would rather have not have granted from how they felt about it because the applicant was entitled to the approval.
Right. Just the number one thing in zoning is protecting the health, safety, and welfare of the general public. So that is what you guys are enforcing. I am not trying to impugn your reputation. I'm just saying that should have been something that came out. I didn't understand why you were being so tough on us, because as residents, I would think that you would care deeply about residents having a voice. So thank you. I appreciate you hearing my issue, and I appreciate it being on the record. Thank you.
Thank you. Are we okay on the stipulation for April or for the March meeting? All parties?
And if it gets continued to April, then the deadline is the Friday before for
Whatever
all
month-
materials.
whatever month we do the hearing in.
Stipulations, they have to be in the Friday before.
The only question I hear now that another memorandum may be submitted, and obviously I'm not going to have a chance to reply to it. I don't know if any more new issues would be presented in that. I would just ask John that, if it's presented on Monday or Friday, I get a couple days at least to look at it and present it.
That's why I wanted it on Friday, so that everybody has a little bit extra time.
Yeah,
in
and you
case.
can speak to it at the hearing. By the way, this is, everything has to, but when something has to be served, and Ms. Perone, I don't think we have an email for you as a party. Anything that is going to be served has to be served on everybody, okay? Not just, it has to be served on counsel for the parties, and that means Ms. Price's attorney, and I would ask that, Ms. Price, if you want your attorney to receive service, Ms. Perone, that you would leave email addresses with, I guess, Matt, to make sure that, because Matt, what you would get, when you get something in, you can circulate it right away.
I will.
I point out, by the way, that the township offices close at 4. To the extent email addresses are sent to me, I will circulate stuff that I get that's subject to service of the parties. Again, I don't have all the emails. But to the extent you can serve by email or you can serve by paper filing, the paper filings actually have to be received by everybody by the cutoff date, which is close of business on that Friday. And to the extent it's the township closes at 4, so you can't get your paper filing in at 5 o'clock. Township closes at 4, and we really need to be careful and meticulous that everybody gets a copy on time.
Okay?
Does everybody have everything now? The 4 parties that are of record, do you all have everything that exists to this date?
Anyone who needs to get information, they need to let
Okay.
the
Could you
the
give a
lawyers
copy of
and
that
solicitor
also to
for the
Mr. Brown?
township and for both universities to have your name and your email address. Okay, so
Ms.
that you can
Brown,
get it.
I'm having a little trouble reading that. Is it me?
Well, I mean, they said that. Any neighbors? Okay? All right, thank you.
Is there a dot?
Appeal
1R?
2846.
Okay, I would not have gotten that.
The applicants Gary E. and Christina M. McLean, located at 402 West Wayne Avenue, Wayne, PA, and is zone C1, has a new tenant who wants to operate a daycare for up to 12 children on the first floor. Applicant already has a residential tenant in the second floor who is unrelated to the operator of and who is not involved in the daycare. Applicant seeks approval for this modification either by removal or modification of one or more of the conditions of the decision of the Zoning Hearing Board dated September 18, 2008, in Appeal Number 2785, or by special exception, variance, or declaration that no additional relief is necessary. The same sections of the code will apply where applicable in Appeal Number 2785. How are you this evening?
Fine, how are you? Good
I'm
evening.
fantastic, thank
Members of the board, I'm Edward Flail, here for the applicant, Gary and Christine McLean. They are not here tonight. I have an affidavit to hand up, which I'm required to do now.
Power of attorney?
Power of attorney, appointing me to be their representative, both as a witness and as counsel.
Okay, let me have a look at that.
I use the township's approved form, Mr. Ryan.
Flair, you ready?
Does everybody have all
Yes.
the exhibits? I didn't have a copy of the photographs or professional reports. It was indicated that those things were enclosed. Were they submitted?
They were part of the record from the original appeal, and we're going to make that part of the record in this appeal. So I don't believe they were separately attached.
I mean, the application, Mr. Flail said, please indicate whether the following additional requirements are included. And it was checked off yes for photographs and yes for copies of written professional reports. I just want to make sure I'm not missing part of the materials. So I reviewed what I got, but I didn't get those.
No, I think the photograph is a reference to the aerial photograph that is attached.
There is an aerial photograph.
Right.
I mean, I got that.
That's the only photograph.
I have no photograph. What's that? Yeah, I didn't get that.
Well, I have an extra copy if you'd like me to hand it to you now.
Oops, I do have it, sorry. If that's the only one there is, I have that.
Okay.
Now, what's the professional report that was supposed to be attached? Is that just the plan?
Just the notes on the plan.
Okay. Then I have what I need. But there is no deed, though. No deed was submitted. Isn't that a requirement, John?
I'm sorry?
A deed or
Yeah,
proof of
there should
ownership?
be a deed in there.
It's checked off no, and there isn't one.
And the lease as well. Wouldn't we need the lease? Isn't there a new tenant, potential new tenant?
There is.
Okay, there should be a lease as well?
I don't know that there's a lease even
I
been.
don't think that, I think what they need to do is the owner applying is to have a deed. I don't think they need to show the
Okay.
lease. They need to describe what the use is, and they need a
Okay.
deed.
Right.
The lease may or may not be relevant, depending where we're going, but the deed needs to establish ownership, and it's not here.
No, it is not here.
I don't know if I even have a copy of the deed to give to you.
Do we
so.
have one in the original file on this?
Well, I'm looking to see if it's,
The
is this the
original-
original file?
On Appeal 2785, Mr. and Mrs. McLean were not, oh, wait a minute, I better not say that. Maybe they were.
No, this isn't, right.
According to the decision last
get
time,
that-
they
get the
were
deed,
under
yeah.
agreement of sale, but they didn't own it. So a
Well,
deed is,
Matt's going to get the original file, which should have the deed in it.
2785.
no, they didn't own it then. There wouldn't be a deed. The original decision states that they had it under agreement of sale.
Okay.
They were not the owners. There won't be a deed in there, Matt.
Yeah, there won't be a deed in there.
They
Mr.
were,
Rice?
they were not the owners when they made the last appeal. They were just tenant, they were purchasers under an agreement of sale.
Okay.
Township does have tax records that show they're paying the
Take about
taxes.
a 5-minute break to clear some of this up.
Okay.
This case. Because, I mean, if there's no deed and there's no lease, then there's no standing to go forward.
Well, they wouldn't need the lease with the tenant for standing, but they would need the deed. Establish their
So
standing.
We can find that.
All right, why don't we hear the next case and while they're looking? How's that? Would that be okay, Mr. Flair? If we start the next appeal,
Absolutely.
and then that way they can see if they can find a deed for you?
All right, the next one's short, and the board did authorize me to attend this one with Matt.
Okay,
There's some questions that, we may have cleared it up earlier tonight, but.
okay, excellent. Thank you very much, Mr. Wright. Is that okay with the board? We'll move on to the next one. This is all your fault. All right. Appeal 2847.
Mr. Falcone, that should go into the file for 2846.
2846.
Look.
2847, excuse me.
Hi.
The applicant, Michael Ellis, located at 112 Valley Forge Terrace, Wayne, Pennsylvania, 19087, and is zoned R4, seeks relief from 280-32 accessory structures from the minimum rear yard setback requirement of 3 feet.
Shall I swear him in? Sir, if you'll raise your right hand, you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
And state your full name, please.
Michael Ellis.
Thank you.
Okay, Mr. Ellis.
I was told by Matt Bauman, who, the last inspection for my property, I had a garage built on it. When the last inspector came out, he measured the corners of the properties and found one too close to the property line on the back. This was a mistake by the contractor that built the concrete. It was inspected back in 2009 by John Peely, I think it is. I have the inspection report here, when he inspected the backfilling and the footers. Basically what happened was the concrete work, the concrete contractor had made some mistakes on the concrete, the block work that comes up off the footers. And the inspector came out, because I had called the inspector because I was upset with what he was doing. The inspector came out and made him tear down the block work and rebuild it because he wasn't set in the center of the footer. So I guess this corner got closer. I never knew about the corner being closer until the whole structure was built, which was inspected just the 15th of December. So I didn't even know that this corner was this close to the property line.
Mr. Ellis, is this a plan? By the way, we ought to label your exhibits. Let's do that first, if we could. Let's label your application as A1.
Okay.
Let's label the two deeds as A2. There is a plan here, and it is prepared by, it looks like it's prepared by John Smerga.
Yes.
And this is as-built, and I was going to label that A3. Now, does the A3 plan show the intrusion correctly? Does it
Yes, on the
show
back property line, the corner closest to the house.
Okay. Then there's a bunch of, a packet of photographs, and I would like to suggest that we label those A4.
I don't, okay.
I thought I had to give in pictures, that's why there was pictures.
Okay. Mr. Ellis, looking at your plan.
John, I'm going to do all four A4?
Yeah.
I'm going to make them A41, A42.
Or A4A or A4B or A4C, want to do that? Okay, let's do that. We're going to do these sequentially. There'll be A4A, A4B,
A4C,
A4D,
E,
and I think
and
F
F.
is the last one.
Okay, right. A through F.
I'm not sure I still have mine in the same order as you, so if we refer to them, I'll just say which ones they are, so.
And the garage has been misplaced so that at the closest point to the property line is 2.31 feet,
Yes,
and the requirement is 3 feet.
yes.
And so for about half of its length, it seems to be into the 3 foot and going up to 70% of up to 8.4 inches, something like that.
How much is an inch on?
It's 2.31 feet, so that would mean that it's shy by 0.69 feet, which is, 8 feet some inches.
Point 69 feet?
Yes.
No, you mean
0.69 feet is the intrusion at its worst. It doesn't.
7.5 inches, not feet.
Yeah,
Okay,
yeah, inches, I'm sorry.
okay. I was going to say 7 feet, 7 inches, okay.
Yeah, it's up at its worst.
At its worst point.
And it declines from that, and then eventually at the back, it's actually a little better than it needs to be.
You can
Questions?
actually see how he skewed the building because the other corner is, I think, 3.
Did you say
6
the
or
township
3.9.
inspected this?
Yes, yeah, I have the inspection report, which I got later on, if anyone would like to see it.
No, I mean, when the reason why you had them reset the block on the footings, you said that the township came in and said he did something wrong?
Right,
Now,
right.
did he move them closer or further away from the property line when he did that?
On that corner, he moved it closer to the property line.
Okay.
But basically, the corner block wasn't set in the center of the footer because he, I guess, poured the footer wrong.
Okay.
So,
Did the township inspect the footer when they put them in?
yes, there's an inspection report here, yes.
Questions? No questions, Noah? Cora? Well, I mean, that's what I was hoping.
That's okay. Don. I've already spoke with my neighbor. They all understand. They didn't have any complaints. Matt
You have
and I
any-
spoke about it before, so.
Is there anyone here to speak for or against this issue? That's all you have to say?
Just me. That's all I have to say,
Okay,
yeah.
move your exhibits to be put into the record. Say yes.
Yes.
Okay. Noah, we'll let you do this one.
What would you like me to do?
I want you to say whether we,
I make a motion that we approve the application as filed. Grant the variance,
Okay.
de minimis, on de minimis grounds.
right. I agree. I also think that the fact that the township did inspect it, and they should have picked it when they moved the block back and set it on the footing that they were going to encroach those couple inches. And so I think that you kind of got caught.
Yeah.
But you're okay.
I thought he had noted that. He didn't.
Very good, thank you.
Thank you.
Did they come back yet? No, okay, we'll move on. Appeal 2848, the applicants Donna and Christina Calamaro, located at 813 Hunt Road, Newtown Square, Pennsylvania, 19073, and is zoned R1. Seek a variance under section 280-20E from the rear yard setback and/or a special exception under section 280-101B1 of the zoning code to construct an addition to their home. In the alternative, applicant contends that the relief is permitted as a right if the yard where an addition is proposed is treated as a side yard.
Hi.
Hi.
I'm waiting for my attorney. I'll
You're-
swear in.
Nick is doing double duty tonight.
Okay, sir, if you raise your right hand, you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
And state your full name, please.
Donald A. Calamaro, C-A-L-A-M-A-R-O.
Evening again, Nick Cornelia representing the Calamaros. And Mrs. Calamaro is seated in the back also. There you go. Yeah, let me step over here. Sure. Okay, Don, what's your relationship to the property?
I'm the property owner.
With your spouse?
Yes.
Your wife, who's president in court, as we talked about
Yes.
this evening? And when did you purchase the property?
Approximately 12 or 13 years ago.
1997?
Correct.
And we've marked that as A2
Yes.
on the deed, correct?
Yes.
And when was the house built?
Approximately 45 years ago.
Okay, about 1964, 1965?
Yes.
In that area? And actually, we have, as an exhibit, a blueprint from the original home, is that correct?
That's right.
What's the current square footage of the house, would you estimate?
I estimate about 2,800 square feet.
All right, and I'm going to show you what's been marked as Exhibit A5 first, and I'll come back to the other ones. But on Exhibit A5, is this a property survey of the property?
Yes.
And it's a classic pie-shaped lot, is that right?
Yes.
And actually, not only do you have two front yards, but you have almost, all front yard except for the one side.
Correct.
And you have a pie-shaped building envelope as well?
Yes.
And the plan indicates there's an existing porch on the property, is that correct?
Yes, it is.
And that's a covered porch?
Yes, it is.
And we'll have photographs of that also that the board can see?
Yes.
And that covered porch is 32 feet from that property line, is that right?
That's correct.
Okay, and your proposed addition actually is located 29.6 feet from the property line. And I'll point out that the 32 feet, if that's considered a rear yard, is non-conforming because rear yard is 40 feet requirement. Why 29 and a half or 29.6 feet as opposed to 32 feet? Is there a reason why you jut out a couple extra feet?
Yes, because the proposed addition is a study, and it is a very small room, 10 by 10. We really couldn't make it any smaller, else it probably wouldn't be useful. And then the way that the property line sits, we couldn't make it 8 by 14 because in that direction where the line comes in, I would still be outside of the envelope.
Okay, and the lot, and the proposed addition is conforming in all regards except for that property line, is that right?
That's correct.
And we have as an exhibit, actually, the owner of that property has written a letter of your adjacent property has written a letter in support?
Yes, Elaine and John Schaefer.
Okay. I'm going to show you what's been marked as A6, and this has some locations to the Schaefer house as well. And first off, there's a triangular portion that I'm indicating right here, and that's the portion that extends beyond the existing nonconformity, is that right?
Yes.
And that actually is 2.4 feet past the existing nonconformity, and it triangles back?
Correct.
And it looks like it's about 16 feet long?
Yes,
Okay.
that's right.
So we're talking about using, I don't know, whatever formula it is, 1/2 height times width, this about 19 square feet is the portion that's outside of the
Correct.
existing nonconformity. And then also, as to the location from the Schaefer house, actually, the proposed addition is further from the Schaefer house than the current nonconformity, is that right?
That's right.
And what does it say? Currently, the nonconformity is 85 feet,
That's right.
and the proposal is 91 feet?
Yes.
Now, just to show the board some photographs, we've marked as A7 some photographs. And the first one is, the first page shows the view from the front of the house, is that right?
Mm-hmm.
And the front door is actually on Hunt.
That's correct.
Okay. And you have a garage and no addition above the garage?
Correct.
Right. And then you have a view from Goshen, correct?
Yes. And my basketball court.
Right. And the next page shows the back porch,
Yes.
all right, as well as the back of the house. Can you just indicate where the addition would be located?
The addition will be located on the upper left picture. It'll begin just to the left of the air conditioning unit there, and come across the back of the house.
And if you can just show us with the next, which is the third page of pictures, which that indicates. The third page of pictures, can you just tell the board what we're looking at there?
This is the back of this is a rear view of the house. And this is a view from my side yard, and then a view of the side of the home, still on Hunt because of the street curving around.
Okay, and also, we'll go back a little bit, and this is, can you tell the board what this is, which we've marked, I believe, as A4? If you can tell the board what this represents.
This is a blueprint of the house from the builder from 1965. The builder actually lived in the house next to me, which is now the Schaefer's home. And before they moved out, he was kind enough to give me the blueprint for the house.
Okay, and this is how the house currently exists?
That's correct.
In accordance with this blueprint, and it does show the porch?
Yes, sir.
And that's shown where it says rear elevation, it shows the existing porch?
Yes.
And we've marked as Exhibit A3, and that's the zoning ordinance in effect at that particular time in 1965, establishing the nonconformity?
Yes.
All right. And finally, we have a letter from from Elaine and John Schaefer that's been marked as A8, stating that they have no opposition to the proposal.
That's correct.
That's all I have.
Mr. Cornelia, I have this zoning ordinance. Can you walk me through
Sure.
what provisions
Yeah.
I should be looking at to establish that this
Yeah.
property was non-conforming?
And if you look back at that point, there is no provision on corner lots like we have now. Remember, right now, we have a provision on corner lots saying that you need, that corner lots or you have if it's a corner lot, every front yard is a front yard. And then it also specifies what's to be treated as a rear and what's to be treated as a side. In this instance, and I believe that's why the permit was granted here, is that there is no specification in the definitions. It still had 40 feet as the rear yard setback. I think at that time, though, you can basically choose what you wanted to be your rear yard and when to be a side yard. I think in this instance, looking at the code and why this was granted, is they probably were treating this as a side yard as opposed to a rear yard, and probably were treating one of the roads as, if you look at A5, they probably allowed the builder to choose what he wanted to be the side and what he wanted to be the rear. That's the only explanation. There's no zoning relief in the file. The only other thing I could think of is it was a covered porch, and perhaps they weren't treating that as part of the building at the time. You know, and that's why they were establishing as a nonconformity.
But they did have the same provision we have now, except it was stricter. Right now, we exclude eaves and things as long as they don't project more than 2 feet.
Right.
In this one, it excludes them, period.
Yeah.
So actually, it was a violation when it was built unless...
Well, unless they allow you to take the side of the house facing Goshen and treat that as your front yard. Because then I think they need a 60-foot aggregate and no individual less than 25 for the sides. They'd
Which
have
complied, yeah.
40, looking at this particular ordinance,
Yeah.
I mean, to me, it's a...
Was this the original plan that it
Yeah.
was built from?
Yes,
So there's no doubt this was originally part of the house.
correct.
Yeah, no, I remember too, you know, we used to talk about you could choose your front yard or your rear yard and what is your side yard, or choose your front yard, but obviously the code now states that you have 2 front yards. And I know at one time, it used to be interpreted, and maybe from the old ordinances, that you could choose which one was your front, which one was your rear, and therefore one would be treated as a side instead of a rear. Now, I don't think our code specifically states that now, though. But I know at one time, appearing before the board, there was always discussion on you can choose which one you wanted to be your rear, or which one you wanted to be your side. And that may come from the old ordinances.
So what's the hardship?
Well, one, you have the pie-shaped lot. You have...
But there's always a pie-shaped lot, right?
Oh, not like this
It was
one.
always...
Look at that.
No,
This
but
is the classic.
this lot was this way when he bought it.
No, this is classic. This is a classic pie-shaped lot.
But it was this way when he bought it. It was this way when the house was built. It isn't like someone has taken some of it and made it
Yeah,
pie-shaped.
but this is the, when you look at it, this is as far as a variance request is concerned.
What you saw is what you got.
This is the classic pie-shaped lot, which obviously affects the building envelope as well. And the way the building was placed, as you see, it's not placed kind of parallel, turned with the building envelope. The way it's placed is it runs up against the building envelope. If it was turned, he would have had enough room to put this addition on. It's really the placement of the house on the lot, the pie-shaped lot, and the fact that we do have roads that kind of run the entire extension of the property except for that 1 yard. And obviously, there's no harm to the neighbor as they have written a letter in support.
I think
Did you ever think of locating it on the southern side of it, south of it?
Down here? I'm sorry.
I think he means sliding it down so that you're in more in conform. In other words, sliding it south, like you see how he has it built to the north side of the property? Make it come down some.
North there, so we assume that it's up
Yes.
there.
See? You know,
I
see-
mean,
and then you would be.
It would be really difficult because where it ends here is the end of my dining room, and I would be into a room that I don't want to have to disturb my living room. It would really be, I think, really difficult to do it.
Yeah, but it is better that you can adjust there than moving in there and being not in compliance. When you go up, you are taking away that almost 8 feet
What's
into
that?
the setback.
Well, if I'm
But remember, we're only
too...
Court, we're only 2 feet beyond the existing nonconformity.
At 32,
Well, 2.5.
2.5 feet beyond the existing nonconformity.
Well, couldn't that little triangle be shaved off and be in conformity?
I mean, to put the study on and make it 7.5 feet, it makes the room really unusable. And I can't go in this direction. I couldn't make it 7.5 by 15 because even if I go in this direction, because the lot line comes here, I'm still going to be out almost no matter how far I go towards Goshen Road. So a room that's 10 by 7.5 is a really, really small room, I would say,
but
in this
it
kind of a
is a study
situation.
room, right? It is a study, it is not a bedroom.
Pardon me?
It is a study.
It's a study in a mudroom.
Well, the study is outside of the conformity. And I wouldn't be able to I talked to my architect, he said, I really can't make this, if I'm going to do this particular plan, I can't make any of this smaller or else it won't be functional. I won't be able to move around in there, put the laundry in there and that sort
How
of thing.
about making it 9 feet instead of 10?
Well,
I mean,
the
purpose is that then-
what purpose would that serve except I'd still be outside by 1.5 feet if I
Yeah.
made it 9 feet?
So it is the minimum, interference.
Yeah, we're supposed to grant, first of all, we're supposed to find a hardship to justify variance. And then we're supposed to grant the minimum relief necessary to alleviate the hardship. So it's relevant to ask what is the hardship, and it's relevant to ask, can you live with something a little smaller that may be a little less of nonconformity?
Well, is there a hardship with where the house was placed to, it met the zoning code at the time? If the zoning code existed today, if the house were being built in today's zoning code, the house wouldn't be built where it was built.
Correct.
Correct?
Correct.
That's right.
And that's when you see where the house is located in the building envelope and how it's cocked.
Well, the code was the same, except for the definition of the yards. The code was exactly the same. It was 40-foot rear
Yeah, I'm
setback.
not saying, yeah.
Yeah, I mean,
I'm not denying
it shouldn't have
that.
been built then this way unless somebody manipulated the definitions, and it shouldn't be built that way today, but it is there, and the permit was issued for it, so.
Right, yeah.
Yeah.
But I mean, the way too, obviously, as I was saying, the way the house is cocked, on the envelope, causes part of the problem too, in addition to everything else with the pie
But
shape.
we didn't do that.
No, we're not saying that.
Yeah,
I'm
yeah.
just saying, I understand that.
We're just, like Noah had said, it's our job to give you the minimum amount of relief.
Sure.
If there's a hardship.
Share with us, if you would, why this whole thing can't be slid down. You mentioned the living room, but help us understand that.
Yeah, which one?
The other exhibit that shows the plan itself.
Do you have the interior plan that might help if we,
Yeah, this one?
yeah,
This one?
This is your architectural, is that what you're
Yeah.
talking about?
that's not something we have, okay.
Yeah, I'm going to hand that out. I'm going to mark that as A9.
I was going to say, you want to mark that, please?
The actual architectural.
No, we don't have it.
And you don't have that. And I marked both of them. I don't know if you want to.
I just need one for the record.
sure.
I mean, I need at least one for the record.
Sure. And I'll give one. Step up, the board doesn't mind.
Here you go.
Step up and just out.
Is this the official one, Nick?
Yeah, they're both the same. So.
Okay.
I
And I'm
just
going
need
to mark
look
this
at it.
one
I'll give it
A9.
back to you. I'll give it back.
Yeah, A9. I don't know, my pencil somewhere. Here it is.
This is my dining room here, and then this is the living room. And if there's a huge slope that comes off of it slopes down really far because if you see, yes, and then if you see, this is there's a floor. If you look at the view of the house in the pictures, you can see that this is a walkout basement on this side. So if I slide it down, I'm into the living room with this eating area that we're trying to make a little bit larger here. So it would be really difficult, I'd have to build something up because the yard starts to really slope down from here. Right.
The study could run off the living room, couldn't it? Just it would be more of a foundation.
I know this neighborhood. This is across the street from me. I run through here. And
You better recuse yourself then.
The one thing he was talking about the slope, you can
Yeah, I was going to say, it's really steep on that one side. I can't hear you. Okay. Nick, bring the, oh, you got it in your hand. He's got it in his hand. Is it on?
Yeah, yes.
Okay.
Yeah,
Oh,
I'm
okay.
sorry, Norma. When you look at A7, the one picture, the second set of pictures shows the slope, the back of the house closest to Hunt, it shows the slope if the board wants to look at it. The reason why they can't slide it over.
These are the living room windows.
May I? Yes. You see how it slopes down?
You just means it needs a little bit more
I'll
foundation.
show one more picture. You can see that's the house, that's the side of the home, and this is the walkout basement. So this is a full level below where the addition is going. Does that make sense? That's a full level below. So if I move over, I'm sorry, I'll have to, it'll be into the living room, and I have to almost build a whole nother story with nothing underneath it to put it there.
Is this window going to be removed?
That's the dining, yes, that's the dining room window. No, that'll be this right here. That'll be this right here. So the window will no longer be there.
The dining room window will be.
I'm sorry, I can't.
The dining room window will be removed, but the living room windows will remain.
Correct.
I think we have to share the microphone.
Correct.
Talking to hold the microphone.
Yeah, sorry.
You know, we are suggesting to move this 9 feet instead of 10 and move it, you can extend a little bit, 6 inches there. So you get almost same space within.
And why are you not making this wider here?
You know, then
It shows a new crawl
Oh.
space
that
here.
would be ready again.
Right, it'll
It
be
shows a new
because
crawl
of,
space here under this part. You can do the same thing at the other end. This shows you're putting in a new crawl space under the enlarged kitchen. It would be the same thing at the other end, to have a crawl space and have it up at first.
I think, Noah, is that the crawl space, and the other end, it would be almost a full, it's the way it drops from,
It isn't a whole lot less than the full story here on this plan.
the only other problem would be is that I wouldn't really have, wouldn't have the same kind of access to a room over here. I would have to kind of go in, I guess, through the living room into the
The study.
into the study, and it
If I'm the homeowner, I don't want to lose a living room window. I mean, I know that. If I'm the homeowner, I don't want to lose that.
yeah, you got to talk in a way.
If I'm the homeowner, I wouldn't want to lose that living room window, just from the aesthetics from inside and from outside.
I mean, there are a lot more windows. There's a lot of windows in that room. I mean, keep in mind, there's no hardship. I mean, if we had to act technically, we'd have to deny this application.
Although, if say that there was a protestant here. Well, I'm saying if there was I'm protesting this, and you approve this, and this went up to court, they would uphold the ruling because of the shape of the lot and location of the house and all that.
They would. Well, let's test that. Let's find out.
No, I can't. Well, if you deny it, then they're going to uphold the denial. But I'm saying if you approved it, they would uphold the approval.
I'm
There's
not worried
enough
about
here
being
for it to
overruled. I'm
uphold.
worried about doing the right thing.
Yeah, I know. I'm just saying. It's also de minimis, Noah.
Yeah, I agree.
I think I'm the strict constructionist on this board.
I've realized
Okay.
that already. After, in 3 or how many months, I've realized that.
Do you want this back, Nick?
One is marked.
What do you say? Are you going to adjust the line Because you heard the board, you know, we have so
But
much
what- yeah, I don't know
concern
what-
about it.
Give us some guidance, how's the board?
Well, we don't design houses.
I know.
Trying to get an idea of what your flexibility is for relief.
We go for 9 feet instead of 10.
What's it?
And mark it on the order.
I just think that, I think the way the lot sits and the fact that it really does slope a lot, Noah, I mean, if you saw the house, you would see that. I think that his hardship is the fact that it's really a funny-looking lot.
Well, I mean, that may be a hardship in expanding the house.
Right.
But there's no hardship requiring that the house be expanded. In other words, he doesn't have to do something because there's a hardship.
No.
It's if he does it, he has to do it this way because there's a hardship.
Yes, correct.
Different issue. But we haven't gotten over the hardship that has us even dealing with giving relief. That's what I'm saying. This is an optional thing they're doing to their house.
Which
And I
is
don't,
what
I
we
don't
all
blame
do.
them if it makes their house nicer.
Yeah.
But the point is, they want to do it in a way that's going to cause a zoning violation.
You know, actually in our house, our
But I think if he did anything to the
dining
house
room is our study.
in the back, he's going to
The kids were studying.
he's going to have some kind of zoning violation. If he extends the back anywhere, he's going to encroach at some point.
Oh, no, there's at least one way to do it. It's inconvenient, it'll lose a window or two, it may cost a little more to build it, but it can be done.
But yeah,
The point
it's
is, it
also-
doesn't have to be done as a result of the hardship.
But
It's an
also-
optional thing.
It's also a steep slope, but no, again, that theory is no one would ever put an addition on their home. And I know you guys are here to interpret the zoning code and to make rulings.
No, a
on the
lot of us
zoning
have
code.
extra envelope area to build an addition on. He does too, it's just in the wrong place on his lot.
Right.
He's got plenty of unused building
And
envelope.
that's part of the hardship here. I mean, that's what you guys are here to act reasonably.
But again, that's the hardship in
Determine the
that's the
code.
hardship in the where and how, not in the need to do it. That's again.
Nick,
Well-
I think this is a good deal. If you can go for that 9 feet, we will.
What was 9? The 9 feet was, what was it now? 1 foot down? 1 foot down? Give me a minute.
It's a 101B1 for the portion up to 32, and it's a variance for that extra
Right.
2.2.
30.6, I mean, our proposal would be no closer than 30.6 feet.
inches to the
Yes,
rear line.
it's 30.6 feet.
Right, 30.6 feet as opposed to the 29.6 that
Exactly.
and do you want to
please
change
mark
the,
it,
do
please
you want
mark.
to change and initial the drawing?
Yes.
It's going to be, no, it's the other one. I need the record one.
Charlie,
Right, John?
they also, I mean, they should keep it in the same footprint. In other words, they shouldn't take a foot off of the eastern edge and add a foot to the north, so. the
I'm just going to have him change here where it says 29.
Yep.
I'm going to have him change A5
Yeah.
to read 30.6 inches from the rear property line.
30.6 feet, right.
All right, 30.6 feet to the rear property line.
Yeah.
Now, let me ask you a question, and speaking to them, I don't think they can do it, but if they slide it down, we're just going to be no closer than 30.6 feet.
Correct.
Correct?
Correct.
Well,
Yep.
I
I mean,
think.
we're not going to push it up. If that's what you're asking.
Yeah, I mean, and if you push it up, you cannot be greater than 30.6 inches from the rear property
So
line,
you're saying you're
30.6
going to
feet.
take a foot off?
Got to take a foot off the room.
Yeah, he's thinking he probably would take a foot off the room.
Foot
But
off
I'll
the
put
room, right.
I'll put no closer than
Yeah,
30.6
just
feet.
put- All right, John?
Okay.
Okay, and it's A5, he's going to put that on. So if he slides it either way, he still has to
Yeah,
maintain
and he
no
also can't make
closer
it
to-
longer than he can slide it, but he can't make it longer and have more area in the variance.
Well, I thought you said he could add a foot. As long as he, in other words, if it's 10 by 10, he can now make it 11 by 9. But he cannot be any closer than 30.6 feet to the rear property
And
line.
actually, if he did slide it, it'd be smaller, John, because he loses...
If he slides up, it's going to get
Yeah,
smaller, because
it
the
gets
more he
smaller,
goes,
yeah.
the more he goes towards Goshen Road is the more he's going to take off. He needs to initial that, okay? All right, Cor?
Okay. Just initial that there.
You understand?
Yes.
Okay, I mean, you can, you know, you,
Are you cheaper than the one on the?
Sure. I designed the house in the back of an apple. Back of an envelope. I still have it.
Where is it? I'm going to drive by and get some ideas.
okay, any other questions? No, is there anyone in the audience that's left that has any comments? Nick?
Just ask the exhibits to be made part of the record, please.
Cor?
Yeah, thank you, Chair. I vote for granting the variance with a change marked in the plan. Okay.
Okay. No?
Yeah, I second.
I think that we're giving a variance under section 280-20E for the extension to the rear property line not to exceed 30.6 feet at any point. Okay?
Thank you.
Okay, thank you.
Thank you.
Can we take a quick,
Index strict but flexible.
hey, Charlie, can we take a quick break?
Okay. Let's take a quick 5-minute break and see what Mr. Flair is doing.
You sure you want to take a 5-minute break? We're leaving.
Are you done? You're not going to do anything?
We're not going to do anything,
All right,
so
then
if
we
you
will
want to
take a
take a
5-minute
couple
break.
minutes to postpone it,
Okay, go ahead.
we'll be finished.
Go ahead.
The parties have agreed that we would, with your permission, would like to postpone this hearing till next,
Continue
continue, till next,
to the March meeting.
yes, and I'm part Irish, so I like to drink on St. Patrick's Day, so if there's any way cannot be back here, we won't be back here. We're going to try to work some things out administratively, and if all goes well, we may not need to have a hearing at all.
That works for me.
Okay?
I thank you very much.
Thanks.
Ed, if you do bring anything to drink, you have to bring enough for everybody.
Green beer?
Whatever.
Yeah, Mr. Flail, you do give us an extension of time to hear the case and that the 45 days will commence
I
after the
do.
last hearing.
There's no other business in front of the board. We stand adjourned. Thank you.